Homosexuality is protected under what federally protected class? That A, sex, B, national origin, C, homosexuality is not protected under any federally protected class, or D, familial status.
Let's see. I didn't think it was protected.
And C is correct. Good job. All right, good job, guys. So I'm just going to put in the questions in the chat as well as the question rationale. All right, so the commission shall suspend for a minimum of 2 months or revoke the license of any broker or sales agent found guilty of A, second fair housing violation offense, B, fourth fair housing violation offense, C, first fair housing violation offense, or D, third fair housing violation.
Would that be the second? Trying to recall.
Right, so you say A, and that's correct. Good job. See, go with your gut instinct. Cool. So what type of property is encompassed by Ohio's broker lien law? Is that A, single family residence, B, commercial property, C, four-family apartment complex, or D, vacant property zoned residential?
Makes me feel like commercial property, but I don't. Because it's saying broker. I don't know. The property.
So
He said,
commercial is correct. So yeah, so exactly. So Ohio broker lien law covers commercial property only.
okay, yes. See, that's why I be trying to like tie these together to make it make sense. And I know broker deal with a lot with the
Yeah,
commercial. Okay.
right. But they did try to trick you by putting that single family residence in, so that's also a good guess. Okay, so a real estate agent listed a property that was vacant. The agent ran a machine to make the rooms smell good to cover the odor of animal waste. Is the agent obligated to disclose that if not for the machine, the rooms would smell bad? A, if the odor would remain after the machine is removed, then the buyer must be told of the pet damage. B, no, but the agent must never remove the machine. C, no, the agent must tell the selling broker. Or D, caveat emptor says that is the buyer's problem.
So the first one is it's A. If the odor would remain after the machine was removed, the buyer must be told.
Okay, so we have A and C. Is it A? All right, so yeah, A is correct. If the agent is aware of a hidden defect or she must disclose the defect interest is there for interested buyers.
If not, that will be considered what?
I don't know if a machine would cover that much over. Uh, a seller gave her agent a check for getting her house sold so quickly. What must the salesperson do with the check? A, keep the check regardless of the amount. B, the agent may keep the check if it is less than $10,000. C, give the check back to the seller. D, give the check to his broker.
To the broker.
All right, we'll say broker, and that is correct. Can't be directly accepted from the client and has to go through the broker. Okay. An agent receives an earnest money deposit check of $1,500. It would be considered commingling of funds if the agent A, placed the check in his commercial checking account, B, deposited the check in his broker's trust account, C, turned the check over to the seller, or D, held the check until closing.
Place the check into a commercial checking account.
Okay. That's correct. So commingling of funds means mixing your accounts with business, or basically like earnest money or any commission. John, a real estate agent, has been found guilty of violating the Federal Fair Housing Act for the third time. What most likely will occur? A, the commission will suspend John's license. B, John will be fined a minimum of $2,500. C, John's license will be suspended for 2 months, or D, the commission will revoke John's license.
This is the third offense. My gut says they're gonna revoke it because it's already been suspended at 2.
All right,
Mm.
cool. So
That's
you both say revoke. Good job. That is correct. Sorry, sitting outside with my dog. Okay. A licensed property manager is negotiating a lease on behalf of a commercial landlord. The property to be rented is retail space in a soon to open mall. What type of lease would you expect the property manager to negotiate? Is that A, land lease, B, percentage lease, C, net lease, or D, gross lease?
a property manager is negotiating on behalf of the properties and bringing space. Percentage, maybe?
That's a good one. Yeah, this is like a fully loaded. Good job. Yeah, it would be a percentage lease is usually used in a retail establishment with rent based upon a percentage of the sales that the tenant makes each month. Good job.
Oh,
Yeah, we're tearing through these. Good job, guys. Okay, so a seller tells the listing agent that her home was treated for termites a decade ago. Before listing the property, the agent should A, talk to the neighbors, B, tell the seller not to disclose the infestation as it was longer than 5 years ago, C, tell the seller to disclose the old infestation, or D, talk to planning and zoning. That's actually a good question.
oh, the seller to disclose the old infestation.
C.
Wow.
Correct. Good job. Yeah. If you are presented with a choice of tell the seller to disclose and tell the buyer or buyer's agent, the correct choice would be to tell the buyer. It wasn't one of your choices. Tell the seller to disclose becomes the best answer. That's basically the same thing that they're saying, but yeah. Okay. So under Ohio law, a non-licensed employee of a property manager may A, negotiate a lease between the landlord and a potential tenant. B, prepare the lease agreement for the landlord and tenant. C, explain the difference between a periodic tenancy and a month-to-month tenancy. Or D, accept payments of a pre-negotiated rent from a tenant each month.
Accept the payments of the pre-negotiated rent from a tenant each month.
Good job. Key thing in that is them being non-licensed, so they can't do any negotiating. Okay. The rate of commission for residential properties is set by the A, Ohio Real Estate Board, B, broker and the principal, C, multiple listing group, or D, Ohio Real Estate Commission.
Wouldn't that be the broker and the principal?
Correct. Good job. The rate of commission for residential and commercial sales is not set by law, but is completely negotiable between the broker and the seller, aka principal. Okay. What does an agent need to be who does an agent need to notify for a change of his or her home address? Is that A, their local board of realtors, B, the commission, C, the division of real estate, or D, their broker?
The division of real estate.
Right. That is correct. The Ohio Division of Real Estate handles all motion of licenses, including transfers and status changes. So once you guys pass your exam, which you will, you'll go to the Ohio Division of Real Estate website, and then that's where you'll find when it becomes active. Okay. Okay. Who can be affected by lead poisoning? Is that A, children, B, pregnant women, C, elderly, or D, anyone?
Anyone.
Good job. God, I wish I had an easy Hopefully you get easy questions like that. Okay.
They'll be all hard.
I know, right? Under what condition can an assistant talk with a client about the terms of an offer? Is that A, when all of the agents are out of the office, B, when the assistant has a license to practice real estate, C, when the client does not mind dealing with the assistant, or D, when the assistant has the authority of the agent?
When the assistants have license to practice real estate.
Right, correct. Good job. All right, so what would you expect an Ohio property manager to do? Is that A, prepare a land contract in case the landlord wants to sell the property to a tenant? B, convert the apartments into condominiums for the landlord? C, initiate actions for the recovery of rent? Or D, prepare lease agreements for tenants to sign?
Ooh, Ohio property manager. So I'm thinking between the two, initiate actions for recovering rent or prepare a lease agreement, but then is that like a legal document? So is that an attorney? And so I'm thinking C.
All right, we'll say C, and C is correct. Good job. Yeah, so
Sometimes
anything that has to do with like um creating contracts or anything like that, it would be just left to the attorneys to do.
okay.
All right. So if a broker dies and there are no other brokers in the firm, what is true? A, the superintendent must appoint an ancillary trustee with the approval of probate court. B, any salesperson associated with the firm may take over the deceased broker's listings. C, the Department of Commerce will appoint an ancillary trustee. Or D, the Ohio Real Estate Commission may and appoint an ancillary trustee.
No, this is a guess because I can't really remember, but I'm thinking maybe it's the Ohio Real Estate Commission may appoint ancillary trustee.
Yeah, I
Maybe.
think that's how you say it.
Yeah, I'm
Okay, say
thinking
D.
none of them sound right. Like
Right.
probate court, and I know the salesperson ain't gonna take over. And the Department of Commerce, that don't ring a bell.
So it is A. And how I like to remember when if it comes to deaths and then no one else is there to kind of take over, kind of same thing with like a listing and things like if there's no other agent to appoint after a death, probate court comes involved.
Probate always deal with death.
Yeah, right. So whenever I see death, I
Oh, they
associate with probate, but definitely reading through the full question because they will definitely try to trick you there. But majority of the time, if you see death, probate is going to be probably your best answer, or the answer that has probate in it. See? All right, good job. An agent told the buyer that they would have the option of tapping into the new sewer when in fact tapping into the new sewer was mandatory. The agent's action violates A, Code of Ethics, B, Task Force on Agency, C, license law, or D, federal law. Moose. No moose.
Code of ethics, maybe to guess. I'm thinking code of ethics because
Code of
oh,
ethics. So yeah, that was a tricky one. So an agent told the buyer that they would have the option of tapping into the new sewer when in fact tapping into the sewer is mandatory. This would be violation of license law. So since they didn't know completely, it'd be misrepresentation. Yeah, that was tricky.
that was not a good question.
Yeah, that was kind of a good question. Oh, wait, wrote it. A broker advised a salesperson not to take a listing because the seller did not want anyone to know about a hidden defect in the house. What must the salesperson do? Is it A, take the listing but ask the seller not to tell the broker? B, tell the seller that they cannot take the listing? C, demand the commission from the broker that would have been earned? Or D, sue the seller for being unethical?
Tell the seller you cannot take the listing.
Oh no. Yes, that is the correct answer. What happened? Wait, sorry. Here we go. Okay. I don't know what I did. Okay, yes. So tell the seller that he cannot take the listing. The rate of commission that may be charged on the sale of improved property is 0.06. B, the rate agreed upon between the buyer and the sales associate. C, a rate agreed upon between the broker and the property owner. Or D, the rate agreed upon between the broker and the sales associate.
Okay, buyer and sales associate, broker, property owner, broker, sales associate. So we're gonna eliminate the first one and last one. So broker and property owner, the buyer and sales associate.
So,
We go. See if C. Uh,
all right. Emily says C too. Correct. So it would be C.
Good job. She got that, I didn't.
Good job, guys. Okay, cool. Last question. Under Ohio law, every listing agency agreement must have A, the diversity in housing logo, B, a mandatory extension clause, C, the company policy for brokerage and dual agency, or D, a statement redefining the practice known as blockbusting and stating that it is illegal. You say D?
I think D.
Right, yeah, this one was good. And D is correct. I actually didn't know that until I started doing this. So it would be a statement defining the practice known as blockbusting and stating that it is illegal. All right, good job. That was a long one. It's a good. Okay, cool. So what should our next topic be?
New brokerage relationship law.
Brokerage relations. Okay, so I'm good. I don't think we've done this in a while. Okay, cool. All right. Now, what would not cause a real estate sales agent to lose her license? Is it A, a felony conviction for embezzlement, C, violation of the canons of ethics, or sorry, B, and then C, a second violation of fair housing law, or D, violation of the code of ethics? All right, good job. So we got C. Oh, I would say C too. So, okay, so it'd be D, violation of the code of ethics. So second violation would be maybe they're suspended, but I don't think they would lose their license. So the code of ethics is code of professional responsibility adopted by many boards. The code is not legally binding upon a sales agent. The canons of ethics are legally binding as adopted by the Division of Real Estate. A fair housing conviction and a felony conviction are both grounds for revocation of a broker's license. Okay, yeah, that was a tricky question. I think it was poorly worded, but violation of the code of ethics, I guess, would not cause a real estate agent to lose her license. Okay. So what duty survives the termination of a listing? A, confidentiality, B, loyalty, C, disclosure, D, obedience.
Confidentiality.
Yeah, right. I think the other one, No, well, wait, no, whole tree branch was spell. Sorry, guys. Crazy.
He got
I'm
something else.
sorry. It's
Oh,
super windy by me, and there's like a tree a little bit down our street that just a tree branch just completely fell off, and now my dog's going crazy. Okay, sorry about that. A buyer signs an agreement with a broker under which the broker agrees to represent the buyer in dealing with the third parties. What did the buyer sign? A purchase agreement, B, a land contract, C, a purchaser agency agreement, or D, a listing agreement.
purchase agreement, maybe. Yeah, but between that one or a purchase agency agreement, those eyes between those two. Because I know it's not a land contract or nope, not listed. Purchase agreement. I'll just go with A. We'll see.
You say? Okay. Okay, so it does kind of sound like it would be A, but it would be C as the best answer. And it's weird that they call it purchaser agency agreement because another term for it would be a buyer's agency agreement or buyer's agency representation agreement.
That's what
Um,
I've buyer's agency agreement, not the purchaser.
yeah,
So
right. It is tricky with the terms that they use, but let's see, it provides the official name of the agency agreement between the buyer and the broker, the purchaser agency agreement. Yeah, that's a strange name for it. But basically, just being that the buyer's agency agreement or buyer's representation agreement is the same thing as a purchaser agency agreement. Okay. A broker lists a property that he owns personally. One of his sales agents produces a buyer for the property. What must the broker do to avoid becoming a dual agent? Is that A, act as a split agent, B, be a sub-agent, C, be a dual agent, or D, treat the buyer as a customer?
broker list is about.
Yeah, this one's tricky, actually. Sure.
Treat the buyer as a customer.
D. Correct. Good job. When a licensee markets property that he or she personally owns, the licensee may not be a dual agent. The only way to avoid dual agency would be for one of the parties to be the client and the other party to be a customer. Good job. Okay. A sales agent is acting as a dual agent. The buyer asks the sales agent how much to offer for the listing. The sales agent should A, not not offer this advice, B, disclose what the price the seller would take, C, void the listing, or D, tell the buyer exactly what price to offer.
Not offer this advice.
Correct. Good job. Okay. Which would cause a real estate sales agent to lose his Ohio state license? Is that A, violation of a minor traffic offense, B, violation of the code of ethics, C, violation of the canons of ethics, or D, violation of the Board of Realtors Code of Professional Responsibility?
Canon of ethics, violation of canon of ethics.
The canon of ethics, and that is correct. Good job. So we know the code of ethics. It's not one. So yeah. All right. So a consumer guide to agency relationships form must be provided for all of the following except an office building, B, a two-family residence, C, a single-family residence, or D, a condominium.
Office building.
Good job. So that would be an office building. Yes. That was nice process of elimination. Okay. A broker and sellers enter an agreement whereby the sellers owe no commission if they find their own buyer. What type of listing agreement have they signed? A, multiple listing agreement, B, exclusive agency, C, exclusive right to sell, or D, net listing.
Mm, maybe exclusive right to sell.
So exclusive right to sell agreement is what we use. So even if we didn't find the buyer, we would still earn a commission.
Is that what that is?
Uh, this would say the sellers owe no commission.
Exclusive agency?
Exclusive agency? Let's see. And yeah, it would be exclusive agency. So this is where the broker would not be owed a commission if if he or she didn't find the procuring cause of transaction. But the exclusive right to sell is the broker always is due commission, and that's the most commonly used.
Okay.
Yeah. Where when it says that there's no commission, if the sellers find the buyer, then that's gonna be the exclusive agency. Okay. Broker Bill Brewer engages in exclusive agency listings with his seller clients, and the seller enters into an agency relationship in which the seller is going to market her own property. What document must be included in listing the file? Is that A, a land contract, B, an option, C, a waiver of duty statement, or D, a lease?
Um, would it be a waiver of duty statements?
Yeah, I think that would be the best answer. Yep, that is correct. All right, good job. Okay, so a buyer should never hear his or her real estate agent say which of the following. A, I cannot withhold any offers even for one. B, I cannot withhold a hidden defect. C, I cannot act as a dual agent per broker policy. Or D, I cannot take that offer to the seller.
Buyer should never hear his or her own real estate agent say. I can't take the offer to the seller, maybe. Okay.
All right, good job. Yep. You literally have to, so no matter what, no broker or salesperson has the authority to withhold an offer from a seller. Every offer must be presented. Right. The relationship in which the agent is placed in the position of trust and confidence is described as A, fiduciary, B, disclosure, C, implied agency, or D, brokerage.
Fiduciary.
Correct. Good job. A fiduciary is someone who is in a position of trust and confidence. While you are on floor time, a buyer asks you to run the MLS and let them know what's available. You tell them that you need to ask them a few questions in order to know what price range they are in, and they agree. You pre-qualify them yourself and pull up a number of listings. You schedule some showings and sell them a home that weekend. The law requires you to A, do as they ask after you must follow the legal instructions of your client. B, have a lender do the pre-qualifying. C, give the client a consumer guide to agency, which outlines your brokerage policy before you start working with them as a client. Or D, give them the agency disclosure form before you show them the first house.
Remember
That's a
these.
tricky one. Oops, sorry. What was it?
Uh, uh,
Read.
give them the agency disclosure before you show them the first home. Or give the client this one, give the try give them the agency disclosure before you show them the first house.
All right.
Oh, it
Okay.
was the other one, a consumer guide to relationship.
Yeah. Right. And so the thing is, so like a lot of these kind of are the right answer, but I guess the best answer would be the consumer guide to agency relationship. But the buyer could go to a lender for the pre-approval before working with them. So you definitely want to make sure that your buyer is either pre-qualified, yeah, definitely pre-qualified, pre-approved, with a lender or a bank or whoever, because that gives you a better idea of what they can afford and a house for purchase price when you go on a house hunt with your buyers. Key. Okay. So Brian is looking for some property to buy. Brian hires a real estate broker to help find a property. Brian signs a purchase agency agreement with the real estate broker. Brian finds a for sale by owner property and makes an offer directly with the seller who accepts his offer. What must the buyer have to give the broker even though the broker did not assist in this transaction? A, nothing. B, the seller closing costs. C, the rate of commission negotiated in the purchaser agency agreement. Or D, copies of the purchase agreement.
The rate of the commission negotiated in the purchase agreement.
Correct. Good job. And then this we'll get into lots of training on to go ahead and do that as well. So who is not an agent or sub-agent? A salesperson employed by a broker. B, a broker who has listed an owner's home for sale. C, a non-licensed personal assistant for an agent. Or D, a property manager managing properties for others.
A non-licensed personal assistant of an agent.
Correct. A listing agent represents a seller and therefore owes fiduciary duties to the seller. What duties are owed to a buyer slash customer? Is that A, duty to keep the buyer's information confidential? B, duty to obtain financing for the buyer? C, duty to disclose latent defects? Or D, duty to disclose patent defects?
To duty to keep the buyer's information confidential.
Oh, wow.
Latent.
So listing here says they were owes fiduciary.
Why it was too late?
Yeah, so this
I knew.
one's tricky. It's honestly, this is kind of a bad question as well, but it would be the latent defects as, but at the same time, you would also try to respect the your fiduciary duties. You don't have to for because you don't represent the buyer. They do only go with your client, but I guess the best answer here would be to disclose latent defects in regards to the listing agent's duties to their buyer and customer. But if they do find some confidential information about the buyer, that would be a duty to keep it confidential. That was a tricky question. What is not a fiduciary duty of an Ohio real estate licensee? A, accountability, B, loan arranging, C, care, D, obedience.
Loan arranging.
Correct. Forget what the acronym. Oh, that's what they're saying. A cold. Accountability, care, obedience, law. Got it. Okay, so in creating an agency contract, what is true? A, agency agreements must be in writing pursuant to Ohio licensing law. B, agency agreements for less than a year must be in writing pursuant to the statutes of fraud. C, there are no statutes that specifically cover the creation of agency contracts. Or D, agency agreements must be created verbally.
Agency agreements must be written pursuant to Ohio licensing law.
Right, good job. Yeah, definitely key to get everything in writing, whether it's an email, text, or obviously a contract, definitely get everything in writing. What is an ethical standard that must be followed by an Ohio real estate sales associate? Is that A, treat all people with honor and dignity? B, treat all people honestly and fairly? C, treat all people as you would have them treat you? Or D, treat both buyer and seller equally?
Treat all people honestly and fairly.
All right, good job. So I guess there's a few answers in here that could be correct, but the best answer is that one. Good job. X lists a property. X finds a buyer. Is X allowed to write an offer as a buyer's representative? A, yes, if it is specifically written in the offer. B, yes, as long as both parties agree in writing. C, no, it's against federal trade laws. Or D, no, an agent cannot collect both commissions.
I'm thinking yes, as long as both parties agree in writing, wouldn't this be a dual agency?
Mm-hmm. Yep. And again, in writing is key. So yep. Informed consent is what is required in order to have a disclosed dual agency. Good job. Try to trick you, so you know your definition. Yeah. All right. A listing agent is about to show a property to prospective buyers. The buyers state that they would like the listing agent to represent them as well. The listing agent represents both buyer and seller in the same transaction. This is known as a
Dual
limited, yeah, a dual agency. Correct. Cool. All right. Good work. Now let's see what other one. We did both law.
What about the transfer of title?
Transfer title? Okay, sounds good. Okay, David asked his lawyer for a certificate of title on a property he is about to buy. What is David asking his attorney to do? A, issue a certificate so David knows exactly how much is still owed on the mortgage and that the bank can no longer contest the amount owed. B, give David a document that states David can now make improvements to the property. C, review an abstract of title and give an opinion to David as to who the owner of the property is. D, issue a certificate so David knows he is entitled to a deed on confirmation of sale by a court in foreclosure action.
I think it's D, the last one. No.
Right. So review an abstract of title and give opinion to David as who the owner of the property is. Oh yeah, this is a tricky one. So a certificate of title, also known as an opinion letter, is given by an attorney after examining an abstract of title, stating the attorney's opinion as to who owns the particular property. Yeah, that was a tough one. Okay. On a closing statement, a new mortgage loan is usually A, debit to seller, B, credit to the buyer, C, credit to the seller, D, debit to the buyer. Okay, I kind of remember these from my exam. Knowing the difference between debit and credits to the buyers and sellers. I feel like I had a few questions about this. That's right.
Closing statement, a new mortgage is a credit to the buyer? I don't.
Credit to the buyer. Correct. Good job. Yes. So a new mortgage loan is a credit to the buyer as it reduces the amount of money the buyer has to bring to the closing table. All right. Good job.
I only know that one, so I got that one wrong before.
Oh yeah. Right? I feel like I always got tripped up on that.
I just know mortgage buyer is the credit.
It's credit. They get money from the mortgage. Yes, exactly. The most complete title protection is offered by A, certificate of title, B, abstract of title, C, extended coverage policy, D, standard title policy. Whatever, most complete title protection is on.
So the title certificate and abstract, definitely not those. I don't think it's those. I'm trying to think is what a standard, I guess. I don't
Right?
no.
Okay. So this is a tricky one. Honestly, the they just threw this in there, I feel, but extended coverage policy is,
'Cause I'm
I
like,
guess, the best answer, but
yeah,
on
that
top
was
of the standard. So in addition to the standard policy coverage is the extended policy, which offers protection against unrecorded liens. So just like anything when you buy stuff, when you buy additional and pay for additional things, I guess look at it kind of like that. The more you spend, the more you'll be covered. Okay. Bob's lawyer examines an abstract of title and gives him the opinion that the title is vested in William. This opinion is called A, certificate of no defense, B, chain of title, C, certificate of title, or C, certificate of sale, or D, certificate of title. Bob's law.
I don't really know. I would
Yeah,
guess and just certificate of no defense only because I don't really know what that is. And
right. Yeah, it's not A or B. Oh, it's actually D. Okay. So a certificate of title is known as the opinion letter. Okay. So when you look at certificate of title equals opinion letter is given by a lawyer who has examined an abstract of title. The lawyer forms an opinion as to whom the title is vested. Okay, so certificate of title is the same thing as an opinion letter. Yeah. A buyer insists that a seller sign a document that states there are no unrecorded liens against the property and the seller is the rightful and lawful owner. the buyer is asking the seller to sign A, hypothecation clause, B, property disclosure statement, C, agency disclosure statement, or D, affidavit of title. Uh,
This is a tough one, so.
C,
Is that what you think it is, affidavit of title?
I
I
think
haven't.
that sounds like the best answer. Yeah, so it would be affidavit of title is a sworn statement by the seller that title is good. It would cover the gap between a title search, which shows recorded liens, and any unrecorded liens that the seller knew of. Cool. So the affidavit of title is what the buyer is asking the seller to sign, claiming that there are no unrecorded liens against the property. So this is like basically transferring title to make title is clear is going to be the affidavit of title. Right. Good job, guys. Well, thank you
Yeah.
again for popping on. I put in the chat a copy of my study guide. Here, I'll put it again. Honestly, if you need access to anything for it, it's basically just the definitions, and then a lot of them are like links to various Quizlets I liked using. Quizlets is like a great free way to study, especially definitions, and a lot of some Quizlets even have some of the CompuCram questions on them as well. So yeah, feel free to use that and let me know if you want me to send it a different way. I totally can. Yeah, thank you.